2023 Kleh International Law Lecture. Today's lecture is made possible by William H. Kleh, a graduate of BU Law from the class of 1971, who's here with us today. And by his wife, Patricia Kleh, I think, who will be joining maybe later. In 2011, the Kleys made a generous gift to establish the William and Patricia Kleh Visiting Professorship in International Law and to support this lecture series. International law is a critical subject for any aspiring or practicing attorney in the 21st century. We are living in what is an increasingly global society. The past 14 months, in fact, have made this abundantly clear. And I doubt that the accelerating trend towards globalization is going to change anytime soon. And globalization is not simply about economics, it's also about human rights, environmental justice, prosecutorial ethics, and more. So even if an attorney plans to practice only in the United States throughout their entire career, knowledge of international law is important to a holistic understanding of the law and to civic engagement in our global community. This is what makes the Kleh Lecture in International Law so important. Since it was first established, we have welcomed legal scholars to BU Law from around the world to discuss tort litigation against state sponsors of terrorism, the legality of torture and enhanced interrogation methods, victims' rights in international criminal law, income inequality, citizenship, and violence against women, among other topics. We are extremely grateful to the Kleys for providing our students and our entire BU Law community the opportunity to engage with esteemed scholars of international law from around the world. So it's my honor to introduce the 2023 Kleh Visiting Professor of International Law, Zachary Kaufman. Professor Kaufman's scholarship examines criminal law, international law, national security law, and international and transitional justice. He's on leave from the University of Houston Law Center, where he's an associate professor of law and political science and co-director of the Criminal Justice Institute. He has also taught at Stanford Law School, the Yale University Department of Political Science, Washington University, and St. Louis School of Law, the George Washington University Elliott School of International Affairs. And in addition, he was a senior fellow at the Harvard University Kennedy School of Government and held academic appointments in a variety of places, including Yale Law School, Harvard Law School, Stanford University, and NYU. The author or editor of 3 books and more than 40 articles and book chapters already in his very, relatively short career, Professor Kaufman is currently working on his 4th book under contract with Cambridge University Press. This one on the law and politics of bystanders and upstanders. He's also written for popular outlets, including the New York Times, Washington Post, Chicago Tribune, Boston Globe, Foreign Policy, and Forbes, among many others. Professor Kaufman has served in all 3 branches of the US government. In the judicial branch, he was a US Supreme Court Fellow and a clerk to a distinguished Boston University School of Law alum, Judge Juan Torreya of the class of 1957 on the US Court of Appeals for the First Circuit. Portrait is underneath here. In the legislative branch, he was on a council on foreign relations international. He was a council on foreign relations international affairs fellow, and on the U.S. Senate Foreign Relations Committee. And during that time, he was a lead architect of both the Eli Wiesel Genocide and Atrocities Prevention Act, enacted in January 2019, and the Syrian War Crimes Accountability Act, enacted in August 2018 as part of the National Defense Authorization Act. In the executive branch, Professor Kaufman served at the U.S. Departments of Justice and State. He also has served at 3 international war crime tribunals, the International Criminal Court, as well as the United Nations International Criminal Tribunals for Rwanda and for the former Yugoslavia. He received his JD from Yale Law School, his DPhil and MPhil, both in international relations from the University of Oxford, and his BA in political science from Yale University. So please join me in welcoming our Kleh Visiting Professor of International Law, Zachary Kaufman.
Well, thank you so much, Dean Awachi-Welig, for that generous introduction. And thank you both to the Dean and to the Associate Dean, Andy Roeblant, for so kindly inviting me to be this year's William and Patricia Kleh Visiting Professor in International Law. Thank you as well to Bill and Patty Kleh themselves for so generously endowing this professorship and also this associated lecture. Your contributions to Boston University School of Law are immeasurable and incredibly helpful and valuable. So thank you for that. A few additional thank yous. Thank you to all my new colleagues and friends here on the BU Law staff and faculty for welcoming me so warmly. Thank you to Emily Robichon and Krista Woods, who have made my transition to BU Law so smooth and so warm. Thank you to all my students in the two courses that I'm teaching here this semester, National Security Law and Transitional Justice. I promise you I didn't require them to be here. I didn't bribe them. So thanks for coming of your own volition. And thank you to everyone else here in Barristers Hall and joining us on Zoom today to discuss policing police. So my lecture draws on my article of the same name, which we published this month in George Washington University Law School's George Washington Law Review. And I'm really grateful and thrilled to have this opportunity to share my work with you. It's a particular honor to be speaking with you today while standing in front of this portrait. It's right underneath there. I came in here the other day to take a picture because I knew that the slides would eclipse it. This is the late, great Judge Juan Correa, which you can't see, is behind the screen. So as the dean mentioned, Judge Torruella was a proud 1957 alum of BU Law. He served on the U.S. Court of Appeals for the First Circuit from 1984 until he passed away in 2020, during which he served as chief judge from 1994 to 2001. He was also the judge for whom I clerked and a dear friend and mentor. I thought I'd quickly tell you how we met and how I came to clerk for him. Judge Torruella and I were classmates in graduate school, and maybe that seems surprising given our age difference. This is in the UK more than 20 years ago. I didn't know who he was when Juan, as I knew him then, and his wonderful wife Judy invited me and a few other American classmates over for brunches on Sundays. And during those brunches, he would regale us with stories about his beloved Puerto Rico and also about his experience as a four-time Olympian. After one of the brunches, I decided to Google him. And the following Sunday, I had no idea who he was. The following Sunday, as we were settling in for another fun brunch, I asked him, Juan, are you a judge? As a matter of fact, I am, Zach. Juan, are you a federal judge? Yes, he replied quite nonchalantly. Juan, are you the chief judge of the First Circuit? Yes. Wow, I exclaimed, what are you doing here? And it turned out that because the First Circuit only sits a few days every month, he decided to live abroad for that particular year, and he would just fly back for sittings every fourth week. So Judge Torruella and I stayed in close touch when I later went to law school, and he invited me to clerk for him. And he really was an amazingly true Renaissance person. He was an artist, an author, an athlete, an advocate, an attorney, an academic, and of course, a judge. I miss him dearly. One of my favorite photos with Judge Torruella was from 2010 during the annual Jamboree, as he called it, which he hosted at his Duxbury home for what he called the Banana Conspiracy, which was his group of clerks. So we took one of those pictures that was really popular last decade where everybody kind of tries to jump. And my co-clerks and Judge Torruella himself never let me live it down that Judge Torruella and I had the same vertical, which is to say no vertical, despite the fact that he was an octogenarian and I was less than half his age at the time. BU Law recently established the Judge Juan R. Torruella Scholarship Fund to provide annual need-based scholarships to students at BU Law in perpetuity. And I'd like to encourage you all to contribute to the scholarship fund honoring this amazing individual. Before I begin my substantive talk, I also thought I'd tell you how I came to focus recently on the topic of bystanders and upstanders, as I personally think it's interesting to know why people do the things that they do. It has to do with my religion, my family, and my childhood. I'm Jewish, and several of my relatives perished in the Holocaust. So during my childhood, I learned a lot about the genocide against Jews, how bystanders enabled it, and how upstanders saved so many people, including in ingenious and inspiring ways. Growing up as one of few Jews in West Virginia, I was the target of several instances of anti-Semitism. Simply for being Jewish, some of my classmates spat on me and verbally and physically attacked me. On one occasion, a fellow student who held me personally responsible for the death of Jesus Christ picked me up, turned me upside down, and repeatedly rammed my head into the pavement until I bled. I was gushing blood. I was in the 2nd grade. On very few occasions did anyone, including teachers, intervene. In some instances, it was actually parents and religious leaders who taught these children how to feel and act towards Jews. It was because of these experiences that I learned early in life that innocents can sometimes suffer discrimination. This discrimination can be manifested violently. Many people, even those with the power to help or in positions of authority, will unfortunately remain bystanders or even initiate or exacerbate these problems. That experience was part of my inspiration to focus on genocide, first as a student and then later as a practitioner and more recently as an academic. In particular, I've concentrated over the past 25 years on the 1994 genocide against the Tutsi in Rwanda, also known as the Rwandan genocide. I've mostly focused as a practitioner and scholar on genocide perpetrators, victims, and survivors. But I also have been fascinated by genocide bystanders and upstanders. The precise time that I had an opening in my research agenda to begin exploring the topic of bystanderism and upstanderism was just as the Me Too movement and widespread attention to police brutality in the United States were occurring. So I decided that my first applications of studying bystanders and upstanders would be in those two contexts that I thought were calling out for such analysis. In my future work, I'll turn my attention to bystanderism and upstanderism amid genocide. So that brings us to my new article, Police Policing Police. This article proposes using criminal law to prompt police officers to intervene in their colleagues' misuse of force and to penalize them when they don't. As I'll discuss, the Holocaust features prominently in my analysis, including research on police bystanderism and upstanderism, training on police peer intervention, and defenses that should not be available for violating an officer duty to intervene in their peers' misconduct. The Holocaust's prominence in the topic of police bystanderism isn't surprising, considering that police violence against Black Americans has been described as its own crime against humanity. The article represents the latest step in my scholarship on bystanders and upstanders amid a variety of crimes and non-criminal crises. Throughout this research, I explore whether and in what situations individuals should be held criminally liable for omissions. In doing so, I analyze trade-offs involved in using criminal law to encourage would-be bystanders to act instead as upstanders. My research centers on bad Samaritan laws, statutes that impose a legal obligation to assist others in peril through notifying authorities, also known as the duty to report, or by intervening directly, also known as the duty to rescue. My first article in the series on bystanders and upstanders was protectors of predators or prey. That article, motivated by the Me Too movement, focused on bystanders and upstanders amid sexual crimes. Among other things, that article first identified far more bad Samaritan laws, especially in the United States, than anyone had previously documented, indicating that such statutes are much more common and apply to many more people than had been realized. Second, that article analyzed and augmented arguments for and against bad Samaritan laws, concluding that many of the arguments against bad Samaritan laws are weak, obsolete because of modern technology, or could be addressed through careful legislative drafting. Third, the article uncovered or emphasized different facts or lessons than other scholars typically do when analyzing famous cases of bystanderism. In doing so, I proved that scholars often exaggerate the number of bystanders and minimize, if not completely overlook, the role of upstanders. Finally, recognizing that not all bystanders and upstanders are the same, the article introduced much more nuance within those classifications. My second article in the series was Digital Age Samaritans, recognizing that scholars typically rely on the same 3 or 4 case studies when analyzing bystanderism and upstanderism. I decided to build my own case study from scratch, employing extensive primary sources to expand the universe of cases for analysis. So this article presented the first legal examination of another sexual crime, the first rape to be live streamed in the United States by a third party, which more than 700 people watched in real time and did nothing. That article proposed a model duty to report for the digital age that applies to virtual presence and includes reasoned exemptions for noncompliance. My model statute in that article is limited to serious violent crimes, namely murder, kidnapping, sexual assault, aggravated assault, and felonious assault, and includes 9 exemptions. I've also been publishing essays on related topics. So for example, on the 25th anniversary of the genocide against the Tutsi in Rwanda, I published an essay on 10 lessons I think we should draw from that genocide, including that upstanderism amid atrocity crimes is imperative. Another essay reflects on former President Trump's repeated insults about the loyalty and trustworthiness of Muslim Americans. In response to Trump's slander, I discussed the history of Muslims who have acted as upstanders amid atrocity crimes. A third essay reflects on how Nobel Peace Prize laureate Aung San Suu Kyi facilitated and exacerbated the genocide against the Rohingya in Myanmar. That essay advocates for the Nobel Peace Prize to be awarded only posthumously. To share my research and recommendations with a broader audience, I've also been publishing op-eds on this topic of bystanders and upstanders. And these op-eds have focused on a variety of topics, including sexual offenses and police brutality. And as the dean had mentioned, this line of research will culminate in my next book on the law and politics of bystanders and upstanders, which is under a contract with Cambridge University Press. My work on bystanders and upstanders includes my creation of original databases that I've made public to aid others in conducting research on this topic as well. So one database focuses on bad Samaritan laws regardless of the bystander's profession. It features more than 200 bad Samaritan laws from around the world and throughout history that can be sorted by various filters. These hundreds of statutes include US, foreign, and international law. So on the topic of international law, for example, according to the law of the sea, every state shall require the master of a ship flying its flag to render assistance to any person found at sea who is in danger. As another example from international law, according to the Outer Space Treaty, the next time you find yourself in outer space, if a fellow astronaut of any nationality is in distress, you must help her. My second database focuses on officer duties to intervene, bad Samaritan laws specifically about bystander police officers. This database features US laws imposing a duty on law enforcement officers to intervene in their colleagues' misuse of force, the topic I'm discussing today. So this new article, Policing Police, presents the problem of police officers not intervening in their colleagues' misuse of force. The article explains why current laws are inadequate and proposes a model statute that would better address the serious problem. Using criminal law to punish bystanderism involves unique challenges in the context of policing, which my model statute aims to address. The article is partly motivated by the police killings of George Floyd and at least 2,218 other Black Americans since 2015. Those deaths have amplified a racial reckoning and intensified demands for meaningful overdue police reform. In many of these killings, other officers were present and did not intervene. In the case of Derek Chauvin's murder of Mr. Floyd, 3 other officers who could have intervened, J. Alexander Kung, Thomas Lane, and To Tao, stood by. The most any of them did to try to help Floyd was that Lane, recognizing Floyd's distress, asked Chauvin if they should reposition Floyd, which Chauvin refused to do. And yet, such passive police officers may be the only hope that victims of police brutality have to survive. These officers swear an oath to protect and to serve, which I argue should apply even and perhaps especially when the protection needed is from fellow officers. And police department policies may even require officers to intervene in such situations. So recognizing the life and death stakes of these scenarios and that existing laws and policies are insufficient or flawed in various ways, I thus propose that Congress and state legislatures across the United States enact criminal laws, creating a law enforcement officer duty to intervene in their colleagues' misuse of force. The federal and state statutes that I propose should be bolstered by law enforcement agencies' internal policies mandating the same obligation. Introducing criminal liability for inaction could prod officers to stop their peers' serious misconduct and would promote accountability for those officers who remain bystanders. Recognition of the specific need for officer upstanderism in the United States can be traced to research on the social psychology of bystanders amid atrocity crimes. The primary researcher on this topic, Irvin Staub, is a Holocaust survivor who became a psychology professor here in Boston. During the Holocaust, he was rescued by upstanders, including Swedish diplomat Raoul Wallenberg, who gave Staub and his family and tens of thousands of other Jews protective identity papers. Staub's experience of being rescued inspired him to study both bystanders and upstanders. His work initially focused on children confronting other people in distress. In the wake of the 1991 Los Angeles Police Department beating of Rodney King, during which 23 other police officers stood by, officials in California invited Professor Staub to apply his research and recommendations to policing. Staub's subsequent work inspired voluntary, keyword here being voluntary, police training programs on officer peer intervention, which are spreading throughout the United States and abroad. Two examples are the Ethical Policing is Courageous, or EPIC program at the New Orleans Police Department, and the Active Bystandership for Law Enforcement, or ABLE program at Georgetown University Law Center. A third example of such a program is the Law Enforcement and Society, or LEAS program, the Law Enforcement and Society Lessons of the Holocaust program at the U.S. Holocaust Memorial Museum. Like Irvin Staub, Charles Ramsey, a former head of both the Metropolitan Police Department of Washington, D.C. and the Philadelphia Police Department, was directly inspired by the Holocaust to promote police upstanderism. Unlike Staub, Ramsey had had no personal experience in that or any other genocide, but still he was inspired. In 1998, Ramsey, then the Metropolitan Police Department's chief of police, twice toured the U.S. Holocaust Memorial Museum. During those visits, Ramsey was especially troubled by an aspect of the Holocaust about which he had no previous knowledge, the role of the police. He concluded that the Holocaust provided fertile ground for drawing lessons about contemporary policing, and that this genocide against Jews in Europe was distant enough in both time and space that it could be used as an educational tool without triggering defensiveness from current police officers in the United States. One such lesson that Ramsey drew from authorities' widespread bystanderism during the Holocaust is that police must courageously act when they witness their colleagues violating civil and human rights. Ramsey thus requested the U.S. Holocaust Memorial Museum and the Anti-Defamation League to create a training program for law enforcement officers drawing on lessons from the Holocaust, and he subsequently contributed to that program's development. Known as the LEAS program, the program focuses on the importance of police protecting civilians from the misuse of force. As an example of police bystanderism and complicity, Ramsey cites the German police's passivity and participation in atrocity crimes perpetrated by the Nazi military. And as an instance of police upstanderism during the Holocaust, Ramsey cites the role Danish police played in their country by saving almost all of its Jewish citizens from the invading Nazis. While head of the Metropolitan Police Department and Philadelphia Police Department, Ramsey sent each police department's recruits to the Holocaust Museum to participate in the LEAS program. According to the Holocaust Museum, to date, more than 150,000 police officers from the United States and 80 other countries have undergone the training. But note, like the EPIC Enable programs, the LEAS program is undertaken purely voluntarily by law enforcement agencies. And while these programs are certainly a positive step towards officer peer intervention, because law enforcement agencies themselves currently choose whether and how to provide these courses to their officers, the upstanderism taught is limited in location and enforcement. The vast majority of police who stand by while their colleagues misuse force are not held criminally, civilly, or even administratively liable. For the few who are, there are two laws that are particularly relevant. And while prosecutors have obtained some convictions using these laws, those cases are exceptional. One of the laws is 18 U.S.C. section 242, which criminalizes a person under color of law willfully subjecting any other person to the deprivation of any rights. Two of the bystander officers in the Chauvin case, Kung and Tao, were indeed convicted under section 242 for failing to intervene. However, the need for my proposed model statute is still as pressing as ever for four reasons. First, the mens rea element of section 242 creates a substantial hurdle to prosecute violations successfully. Courts have interpreted section 242's mens rea element of willfully as either specific intent or reckless disregard. Because the strictest interpretation is so onerous, potential violations of the statute are seldom prosecuted. Officer peer intervention, non-intervention may not and often does not yield proof beyond a reasonable doubt that the bystander specifically intended to deprive a person of a federal right. I thus argue that officer duties to intervene should feature a mens rea that is lower than purposely. Second, Kung and Tao's prosecutions and convictions under section 242 were extremely unusual, which might be due to the facts that it was an enormously high-profile case and that there was abundant evidence of non-intervention through witness testimony and a cell phone recording. Third, the third bystander officer, Thomas Lane, wasn't even charged with violating section 242 for failing to intervene. His mere asking Chauvin about whether to turn Floyd over appears to have been enough to avoid such a charge. But my model statute would require more genuine, effective intervention. And finally, unlike section 242, my model statute provides guidance and requires training and policies on police upstanderism. My model statute thus takes a more proactive, targeted, institutionalized approach to combating and punishing police bystanderism than the reactive measures under section 242. The second type of law I'll mention that does not obviate the need for enacting specific, explicit statutory officer duties to intervene is accomplice liability. So let's look at the model penal code's provision on accomplice liability by omission, which many states have adopted. This MPC provision states a person is an accomplice of another person in the commission of an offense if, with the purpose of promoting or facilitating the commission of the offense, he, having a legal duty to prevent the commission of the offense, fails to make proper effort so to do. However, in the context we've been discussing, a perceiving officer may not have the purpose of promoting or facilitating the police violence. A perceiving officer may not have a legal duty to prevent that brutality, and it's unclear what proper effort even means. All three are reasons we need the model statute that I propose. My model statute does not require that the perceiving officer actually intends to promote or facilitate the police violence. The statutory officer duty to intervene contained in my model statute itself creates the legal duty, and my model statute provides guidance on what the effort must entail. And there's a fourth reason, like 18 U.S.C. 242, accomplice liability by omission does not include any required training on intervention or anti-retaliation protection, both of which the model officer duty to intervene I propose does. Officer bystanderism should thus be addressed through Batson-Merit laws narrowly tailored to this problem. Some of these statutes were recently enacted, including here in Massachusetts, but more and improved ones are needed. 23 jurisdictions, 20 states, again, including Massachusetts, and 3 cities have now enacted laws explicitly mandating some form of an officer duty to intervene. My article analyzes and proposes remedies for numerous flaws and weaknesses in these existing laws, such as unclear requirements, weak or no penalties for noncompliance, a lack of mandatory training for officers on discharging the duty, and absence of anti-retaliation measures. Given their many faults and limitations, these statutes should be amended and not used as models elsewhere. So the article's appendix presents my detailed model officer duty to intervene. I've divided my model statute into 9 parts. First, a definitions section. Second, intervention requirements. Third, exemptions from the officer duty to intervene. Fourth, a requirement for a special prosecutor to charge violations. Fifth, types of liability for violations. Sixth, immunities and indemnifications. Seventh, potential defenses that are explicitly unavailable. Eighth, anti-retaliation protection. And finally, requirements of law enforcement agencies, not just officers. I'm only going to mention a few key provisions of my model statute now, and I'd be delighted to discuss more of them during Q&A. So the crux of my model statute is the second part, the intervention requirements. The full text of that part is on the screen and includes that, except for those perceiving officers who are explicitly exempted from this duty to intervene, which I'll discuss in a moment, all other perceiving officers must reasonably attempt to prevent or stop an inflicting officer's attempted or actual misuse of force immediately or as soon as possible. Such intervention must use reasonable, verbal, physical, or both measures. And this provision recognizes that verbal measures alone may be insufficient, but that unreasonable measures of any sort are not required. Applying unreasonably insufficient measures, as I would argue Lane did, which when Chauvin murdered Floyd, does not discharge the duty. And the duty applies regardless of tenure, rank, or law enforcement agency. At the beginning of the model statute, I define the key actors involved in these intervention requirements. An inflicting officer is the officer inflicting the misuse of force, and a perceiving officer is the officer perceiving that misconduct. Each definition contains nuances. For example, for the perceiving officer, first, the person must be physically present. I've included this requirement because, as I wrote about in my article, Digital Age Samaritans, mobile phones and social media have increasingly enabled individuals to become aware of crimes and non-criminal crises from afar. However, because I'm proposing a duty to intervene in this context, rather than just a duty to report, the perceiving officer's physical rather than virtual presence is necessary. Second, the perceiving officer either observes, reasonably should have observed, or otherwise reasonably believes that the misuse of force is occurring or being attempted. And I've included this requirement as a check against willful blindness, and to include situations where an officer suspects the misconduct, even if their view or hearing is obscured. Finally, the perceiving officer either knows or reasonably should know that this misuse of force is prohibited. And I've included that requirement because misuses of force that the perceiving officer doesn't know or isn't expected to know are prohibited should not trigger the duty to intervene. Another key part of my model statute is about explicit exemptions from the officer duty to intervene, of which I propose 4. One set of perceiving officers who are exempted are those who reasonably believe that intervening would directly result in injury or death to a civilian. I certainly wouldn't want officers to intervene if they reasonably believe that they're going to exacerbate the problem for either the target of the misuse of force or another civilian. A second set of exempted perceiving officers are those who lack sufficient contextual information to determine whether intervention is warranted using a reasonable law enforcement officer standard. If perceiving officers do not possess such information, then they shouldn't be expected to discharge the duty to intervene. A third set are those perceiving officers who have no reasonable opportunity to intervene. Again, without such an opportunity, they shouldn't be expected to discharge the duty. And then finally, I exempt undercover officers. This is to avoid situations in which a valuable undercover operation may be ruined, or an undercover officer isn't carrying proper identification, and the inflicting officer mistakes them for and violently treats them as a meddling civilian. A final key part of my model statute that I wanted to mention is defenses that I list that are explicitly unavailable for the officer duty to intervene. First, following a superior's order, as the ex-policemen Kung, Lane, and Tao claim they did when their commanding officer Chauvin murdered Floyd, is no defense. Such an appeal to just following orders, commonly known as the defense of superior orders, was notoriously invoked by defendants at the 1945 to 1946 Nazi trials before the International Military Tribunal at Nuremberg, also known as the Nuremberg Tribunal. The Nuremberg Tribunal's charter and judgment both rejected this defense. The 1950 Nuremberg Principles that the United Nations International Law Commission derived from the Nuremberg Tribunal's charter and judgment also explicitly rejected this defense. The statutes of subsequent international courts, both those that the United States government has supported, such as the ad hoc UN International Criminal Tribunals for Rwanda and for the former Yugoslavia, and other international courts that the US government has opposed, most notably the International Criminal Court, likewise explicitly reject this defense. Similarly, an officer duty to intervene should explicitly reject the defense of superior orders, as my proposed model statute does. Improving policing and protecting civilians, even from fellow officers, should be viewed as a higher priority than strictly maintaining police hierarchy. Under my model statute, it's also not a defense for the perceiving officer to fear peril to themselves or the inflicting officer. Given that police officers are usually armed, and especially if force is already being used, intervening in such situations is inherently perilous for the perceiving and inflicting officers. If such a defense were available, the duty would be obliterated. And given their societal role accepting risks in protecting the public, police officers should not be excused from such peril. Finally, my model statute explicitly rejects qualified or other state-provided immunity to prevent cases in which such defenses would otherwise be successful, as they so frequently, unfortunately, are. Criminal law can potentially prompt upstanderism and punish bystanderism. Given the scourge of officer misuse of force in the United States, an officer duty to intervene should be included among other reforms to law enforcement. Doing so would both help prevent the death of and promote justice for future George Floyds. Thank you.
Hi, thanks so much for doing this. One technical question. Did the definitions section include a definition of misuse of force, or is it just incorporating the thing from the perceiving officer as violative of law or policy? And then the follow-up is, when you say violation of law, does that include violation of things like Eighth Amendment law that involve sort of fact-specific questions? And so how many, there are going to be obviously easy cases.
Mm-hmm.
How many hard cases do you expect to see where it's not obvious until after there's been a trial whether or not the use of force met the legal or policy? Because you're just fighting in terms of law or policy. Anyway, you see where all of this is. I'm just wondering how that's gonna play itself out.
Thank you. Thanks.
Yeah.
It's a great question that I've been wrestling with throughout this entire project. As for folks who don't know, this country has been wrestling with what constitutes a misuse of force for centuries. And different jurisdictions have different approaches to the law surrounding misuse of force, and there are some key, obviously, Supreme Court cases on the matter. Rather than try to tackle exactly which contexts of misuse of force this duty would apply to, I merely refer in the definitions or in the duty requirements to misuse of force that are prohibited by law or law enforcement agency policy. And so in that way, I'm sort of kicking the issue to courts and to other scholars who focus on this other aspect of misuse of force to solve that problem, which is its own set of law review articles and books, while benefiting from that scholarship and that jurisprudence to then trigger the duty. It's not a completely satisfactory way of doing this because as has been indicated, there can and often is ambiguity. And you still also have to first resolve whether the misuse of force itself was unlawful or violated police department policy. But that's at least the way that I've chosen to deal with this. And by the way, I should mention that I intentionally included not only misuses of force that are legal, but also those that violate law enforcement agency policy, because some local law enforcement agencies are more progressive in outlawing or somehow constraining certain uses of force. So, for example, some law enforcement agencies have banned certain chokeholds, even though they're not necessarily illegal in the jurisdiction. So I wanted to include both of those. So thank you for that question.
Hi, Zach.
Yes. Hi.
This was great, really terrific. And I teach a course where we do 242 in criminal civil rights. I have sort of a technical point question, and then also a more, I think, a more general question. First of all, it's interesting to sort of link it to the Holocaust, because I mean, it seems to me, and you can correct me if I'm wrong, that part of that is an effort to change the culture of police departments by linking it to something that's probably way outside of their sort of frame of mind when they're thinking about the culture in a department that tolerates excessive force. There was just a story in the Globe this week about an officer who's been repeatedly charged with, misuse of force and just sort of dances on his merry way. And we have a new commissioner here who's had a little experience with that himself, being subjected to force by his fellow officers when they mistook him from a suspect. But the technical point is, in the part of the criminal statute, when you talk about the officer's state of mind as having to have reason to believe that there's something unconstitutional going on or unlawful going on, does that import qualified immunity without saying so? Because how does an officer know whether a particular use of force is unconstitutional? In the Section 19.3 civil, as you know, context, it's because there's clearly established law in the matter. So how is the officer going to know that? Isn't that going to re-import qualified immunity? And the second point, which is somewhat related to that, is, did you consider putting a civil provision along with this? Because, of course, this kind of statute is most needed in the places where it's least likely to be enforced, right? The places where there's a culture of impunity on things like this. Whereas if you give private victims a cause of action, they can act as in the old-fashioned sort of out of vogue notion of being private attorneys general to enforce the law against violators when the government itself either can't or won't do it.
Thank you. Thank you, Jack. Let me start with the cultural issues surrounding police bystanders and police misuse of force. Many of you will be familiar with the concept of the blue wall of silence, which is this widespread, notorious, well-documented phenomenon within law enforcement, whereby some police officers cover up the misconduct of other officers. And this blue wall of silence is sort of hanging over this issue of misuse of force, and it deters third-party officers from intervening. Part of the way that I want to challenge the culture of this blue wall of silence that would inhibit officer peer intervention is to try to market the officer duty to intervene as also in the interest of officers. It's not only to protect civilians, but also to protect their colleagues, even from themselves. Some police officers, in the heat of the moment, do things that they sometimes regret later, but that can destroy not only obviously a civilian's life, but also their own careers and in many ways their own lives. And so my argument is not only that we need an officer duty to intervene to protect civilians, but also to help officers, help each other in a sense. And my hope is that that is the way to kind of boost buy-in to an officer duty to intervene. But the cultural issues, as Jack is mentioning, are very difficult to overcome given this blue wall of silence. How would an officer know which contexts trigger the duty to intervene? In one of the aspects of the model statute that I didn't share, I require through the model statute law enforcement agencies to train on the duty to intervene, which includes training officers on what the trigger contexts would be. And this is one of the major flaws of existing officer duties to intervene is they don't require any training. And if they require training, it's unclear what they're requiring it on. If you're going to have a duty to intervene by officers, you need a training on what triggers it, and what you need to do. And so to answer Jack's question, law enforcement agencies would be required to train officers to identify situations where a misuse of force as prohibited by law or the agency's own policy would warrant intervention. And then finally, civil liability. In one of the parts of the statute that I didn't share on the various remedies for violations, I actually do include some aspect of civil liability, but I thought it's still important to focus on the criminal liability for a couple of reasons. The main one is that and probably a lot of folks here know this, when officers are often liable for misconduct, the agency themselves will often indemnify them and can pay sort of the civil liability. The problem, in those situations, of course, is that the individualized deterrence is lessened, which would be heightened, which would be built, which would be strengthened by criminal law. There are few people in this country who have more of a disincentive to being imprisoned than police officers. And so if you had that, and I grade violation of an officer duty to intervene as a felony, if you have the threat of imprisonment, the hope is that, just hiding behind your law enforcement agency to kind of bail you out, would be more powerful to try to promote compliance.
I'll try a question now. I'm sorry. I'm also in great admiration of this remarkable statute that you've drafted for us. I'm also vaguely aware that the American Law Institute, about the last 5 years, did a Principles of Policing project. Not a model statute, not even a restatement that courts are supposed to listen to, but principles that could guide policymakers in all sorts of areas. I don't know whether they had anything about the duty to intervene, but I do know that the part of the ALI process that takes place is that they get input, whether they want it or not, from the executive branch, from the Department of Justice, and from local police departments and police unions and judges who say that can't be done and judges who say that must be done. So they get all these different voices, and into the mix, the reporters, try really hard, but they don't always get what they want. If your proposal had been subjected to the, all sides criticism of that sort of, it's a different kind of law reform model. How do you think, where would the pinches have come? Where would you have to compromise?
Thank you for asking that. I mean, my hope is that I've already made quite a few compromises. As you saw, I've tried to be quite thoughtful and comprehensive about exemptions. I've tried to be quite understanding about the precise situations that actually trigger the duty, and therefore what situations would not trigger the duty. I've tried to be thoughtful about the mens rea, but even then still, law enforcement officers, of course, could, and many would, I imagine, object. Again, getting back to this sort of blue wall of silence issue, a lot of law enforcement officers would not want to be legally required to intervene when their colleagues are using force, either because maybe they make a mistake, maybe they make the situation worse. I mean, there's any number, or maybe they just don't want to be viewed as kind of a rat in some ways, right? So, the most sort of serious pushback would come from law enforcement officers themselves. But I'm heartened by the fact that there was a Pew survey sponsored by the Pew Charitable Trust that surveyed a bunch of law enforcement officers and found that, at least in principle, 84% of police officers, or at least those that responded to this particular survey, did agree, again, in principle, to an officer duty to intervene. Now, they didn't see my suggestion that it be a felony for violating, nor did they see the exact, sort of provisions and requirements, et cetera. But I am heartened by this idea that we are starting from at least a principled agreement among the overwhelming majority of police officers that it's important to intervene when your colleagues are misusing force. And there have been some really amazing cases of intervention. I mentioned that that there are 3 cities among the 23 jurisdictions that now have an officer duty to intervene. The one in Buffalo is actually named for the female police officer who intervened and who was assaulted by her colleague and then fired. And her case was actually only recently, after 20 years, resolved that her pension was reinstated. She was given back pay, and it was basically vindicated in the case. Her last name is Horn, and her first name is Carriol. And so the officer duty to intervene in Buffalo is called the Carriol-Horn law. But so yeah, I'm heartened by the cases that we have seen so far of intervention, and heartened by the fact that, again, at least in principle, the overwhelming majority of police officers agree. But there probably would need to be more compromises.
So this is wonderful. I love the way that you situated the project, and it's really a great talk and a great project. I think my question follows on the last couple of questions, just trying to think about the real political situation between state legislatures, prosecutors, and the police forces themselves. I noticed in your map that a number of the jurisdictions that adopted this duty, at least in some form, included Texas, Florida. I'd love to hear any thoughts you have about how that happened as a legislative matter. And then I also would love to hear your thoughts about how you can incentivize prosecutors. So you've talked about the dynamics within a police department, but prosecutors themselves are often protective of the police with whom they have a very close relationship. And so how can one think about incentivizing the prosecutors to bring these cases?
Thank you, Stacey. So the story of how states have developed officer duties to intervene really is born of Derek Chauvin murdering George Floyd. Of the 23 jurisdictions where I found that there are existing officer duties to intervene, only one predates May 2020 when Chauvin killed Floyd, and that's California. But one thing, again, I just want to emphasize is all of these statutes are flawed in significant ways, and all of them are weak in significant ways. And so it's one thing to have a sort of full-throated, very robust officer duty to intervene that has teeth behind it. And it's another thing, as many states do, including many of the red states that were mentioned, that maybe doesn't even have a penalty for non-compliance, has no guidance on what it even means to intervene or what situations trigger the duty. And so I would argue that many of the existing laws are merely window dressing as a way to demonstrate some progress in responding to situations like Chauvin murdering Floyd without actually doing much. To answer your second point about prosecutors, I just want to bring us back to the outline of the statute in D, special prosecution, because Stacey's absolutely right that in many places, not only in the United States, but abroad, prosecutors and police have an incredibly cozy, often overly cozy relationship. And that deters prosecutors from charging police misconduct. And so precisely for that reason, what I've done in a portion that I didn't share with you is to require that the attorney general and or governor of the state, if this is a state law, I've also proposed to be a federal law, appoint special prosecutors from a different jurisdiction than the one in which the law enforcement officer did not intervene and where the misuse of force was used. And the hope with that is to try to get some distance between the exact prosecutors and the exact police whom they would be prosecuting. And I modeled that on some other existing laws that have tried to do that very thing, is to try to get some distance in order to bolster police accountability. because it is such a problem that that the overly cozy relationship inhibits police accountability.
So how does the prosecution begin in that case? You got a special prosecutor in another state. How do the facts come before that?
Well, not necessarily.
Something they have to see on television, or does somebody, a citizen, walk in and say, I'd like to call the special prosecutor and
So just to clarify, not necessarily in a different state, it could be in the same state, as appointed by the Attorney General, the governor, but just in a different jurisdiction. So maybe a different county or city or whatever. And then how does it start? Much the same way that, you know, any sort of matter of police misconduct would start. Either there's a complaint, or there's an eyewitness, or there's some sort of a journalistic observation. And, you know, fortunately, we're seeing more and more such evidence and complaints brought forward precisely because of the proliferation of mobile devices and social media. But also, of course, it means that we're very far away from this problem being solved.
Hello. Thank you, Professor Kaufman. I think I really enjoyed the lecture. So I was wondering about your thoughts on potentially expanding the duty to intervene. One of the things about the Chauvin case in particular is that Chauvin had several red flags on his record. He was actually expelled from a previous department, yet hired anyway. One of the things that I'm very curious about, because when you're dealing with policing, you're dealing with a very specific demographic. In 2015, Loretta Lynch found that many, if not most, police departments had significant presence of white supremacists. That's not even getting into the fact that officially 40% of police officers are involved in domestic violence situations. So from my perspective, what I'm seeing is several red flags that can be, like on the one hand, I see when the misconduct happens, the duty to intervene is very present and very clear. But I also see several other red flags that should honestly disqualify an officer from serving, right? Like, so so I think it's easy to, so do you think that this should be, like, the duty to intervene should be extended to red flags by law enforcement agencies that are hiring?
Thank you, Drew. Drew is absolutely right that we have a problem that some scholars have called the wandering officer, where a police officer who has been fired or has resigned under a cloud of shame and criminality changes jurisdictions. And because there's a little paper trail, or because the new jurisdiction to which they've strategically gone has such an incentive and a need to hire new officers, that they perform shoddy background checks. So one of the solutions, and I completely agree that this is a massive problem that needs to be addressed. One of the solutions could potentially be, we need a better and more detailed federal database of all law enforcement in the United States, including their charges against them and any convictions. And that way we would have a centralized system where any law enforcement agency in the United States could check for candidates' background. Now we're in the unusual situation in the world of having so many law enforcement agencies. It's something like 17,000, whereas some countries have in the single digits, England, Australia, and others. So there's a big coordination problem, and some of these rogue cops that are run out of town in their old precinct, can exploit the lack of centralized, sort of checks and accountability. So one solution is we need a much more detailed and current federal database of law enforcement. Other things we need, higher standards for hiring. Higher educational standards, higher professional standards. We need better training of officers. And as I've indicated in this model statute, training on the officer duty to intervene would not only be required for rookies, but would actually be part of annual training so that it's not forgotten and so that it's updated to be more contemporary. And then finally, of course, and this is sort of what, the main thrust of what we're talking about, we need obviously much more accountability of police officers for their misconduct. And that is indeed part of what the duty to intervene seeks to do. Thank you, Drew.
Hi, phenomenal presentation. I was wondering about whether the special prosecutor institution is robust enough for this task. And I'm thinking about the challenge of building political will around George Floyd's murder, and thinking about the unrest and the deaths that occurred during those protests, and sort of the cost in many ways of those protests. And I'm worried that something like that would be necessary to trigger the attorney general or governor sort of every time, in which case the gains are rather small from this regime. And so I'm wondering, I'm sure you mentioned federal legislation as well. I wonder if a federal institution would be a more robust and more regular way to monitor for and address these issues as they arise. In a population of our size, they're more likely to arise with a national view than if you're in Delaware or Mississippi, and a level of regularity that can be monitored and tracked and held accountable.
Thank you, Chris. Absolutely, and we need to be mindful of the fact, of course, that different states have different levels of resources and different political will for promoting police accountability. So a federal solution might be a better or at least supplemental way. It also wouldn't be out of the question. I mean, the U.S. Department of Justice, of course, is involved in the process of overseeing law enforcement agencies themselves, and gets involved with consent decrees and so forth. That, if you take it sort of an additional step in sort of focusing on individual, officer accountability, it seems to be, within that sort of ambit. So, if there is a federal sort of, component to this participation, I think that there's a good reason to believe that the U.S. Department of Justice is a completely appropriate, place to do that. And then, in addition, I did mention that 18 U.S.C. 242 was successfully used to prosecute and convict at least 2 of the 3 officers. And so maybe, and I would think we should see more prosecutions under 242. The problem, again, just being the mens rea level is so high that it's often insurmountable. And so that's why either we need, one potential solution that would be just amend 242, lower the mens rea element, or have a supplemental federal officer duty to intervene that's specifically for this situation.
Great. Zachary, terrific presentation. Really, and it's such an important topic. I'm going to follow up on Stacy and Chris on the prosecution design question. But first, I did take a look at your paper on misprision of a felony. And it turns out the history is even more friendly to your argument here, because in England, in the medieval period, misprision had a higher standard for officials. It didn't require an active concealment. It was actually just inaction, omission. And so there's been at least a historical difference that we've lost, where misprision for officers had a higher duty of reporting as opposed to a duty not to cover up. So that might be one way to reinforce the pedigree of your proposal. But following up on Stacy and Chris, there are ways to design this. The other historical point is that prosecution in Anglo-American history is mostly private. I'm not saying that that's an easy way to fix this, but private prosecution is at least a model, and maybe a private prosecution, and there are about a dozen states that still have private prosecution. It's all statutory in states. So if you had you could add a statute here that for this kind of case, you could have a private prosecution. But there's also this recent controversy in the Danziger case, where a federal judge referred a crime to the DOJ. The DOJ declined to prosecute, and the judge took it as a judicial power to judicially prosecute. And so there's a question, as I think it's wrong, but there's a challenge to that being a separation of powers problem. But there's no separation of powers problem for states, and a state statute could empower judges to not just a special prosecutor, but a judge with maybe more independence
Mhm.
could initiate or statutorily have the power to guide that prosecution.
Thank you, Jed. So for those who didn't know as much about misprision of felony, this was a criminalizing omission, but in the United States at least requires active concealment. I wasn't aware that in the UK it didn't include the act of concealment. I'm curious, do you know why that the act of concealment was introduced in the US? Because it raises the bar, of course, unfortunately.
So the statute, the misprision statute, does not require concealment.
Yeah.
It is a judicial, my understanding is it's a 19th century limit. It turns out that in English history, the English had a higher sense of duties for officers, and it's been a modern American project to give officers more latitude. The invention of qualified immunity, for example. This is an American problem, not a common law problem.
Interesting. And then on the point of creative ways to prosecute, I mean, I take that as a friendly amendment in addition to explore. I'm open to, any other ways to promote accountability, recognizing again the limitations on prosecutors pursuing police accountability. So I like these ideas certainly of exploring other ways to do that.
Isaac, as you well know, in the last, say, 10 years or so, there's been rising and broadening skepticism about criminalization as a solution to anything at all. There's, among other things, apart from the abolitionists who have become almost mainstream and like, there's almost no research out there to support that criminalization in incremental ways adds deterrence to anything. It could be the case here, but there's not a lot of research to support that. And you're up against not only the kinds of institutional obstacles that people have mentioned so far, but there are a whole bunch of other ones, whether it's prosecution design, how do you fix that? Some good ideas, but there are a million things in the way there, and a million things in police departments obstructing these kinds of prosecutions. Right. I mean, we have criminal laws now that cover some of this stuff, and not a whole lot of cops are getting prosecuted. What's the sanction in the statute? Is the sanction calibrated in some way that's not just going to increase the footprint of the prison system, but is actually going to deter harm in a meaningful way? Will prosecution not simply perpetuate the kinds of systemic racism that the criminal system as a whole has been credibly accused of? There's lots of evidence, of course. The impact of the system is highly disparate by race, and there's plenty of evidence of deliberate racism in the system. What would be any different here? Would this just be Black cops getting prosecuted and nobody else? So all of this goes to why criminalization as a solution to any of this, as opposed to finding ways to go in and reform the institutions of both prosecution and policing, et cetera. This could be a part of that, but it's hard to see why this would be the starting point, or why, in fact, it would actually reduce harm at all.
Thank you. So like, so many other people, I'm terribly concerned about mass incarceration, about the disparate impact of criminalizing any amount and any nature of conduct. And yet still, I want to argue that criminalization in this case is crucial. Before I do though, let me mention that while overcriminalization is certainly a concern, I would also argue that in some contexts, undercriminalization is also a concern. And here I'm thinking of sexual crimes. So sexual crimes are the least prosecuted type of criminal offenses. We know that they often go unreported. When reported, they're often disbelieved. And so, there's quite a lot of data to suggest that there's actually an undercriminalization problem in the case of sexual offenses. Similarly, I would argue about police offenses. And, we only need to look at the headlines every couple of days to see the latest police offense that goes unaddressed. I've tried to make the argument that civil liability alone is insufficient because it basically passes costs on to not only the law enforcement agency, but also insurance companies. If it's even, if there's even a sort of a finding of liability. And then I don't disagree with having police reform. We need police reform. We need trainings. We need better management. All of that should occur, as well as, again, I would argue, alongside the criminalization of this particular act. Now, when we're thinking about mass incarceration, we're thinking about, among other things, what would be the impact of a new criminal law on the overall police population? I mean, of the overall prison population. Given how few Americans are police officers, and given the further subset of how many allegedly misuse force and then do so in the presence of someone else and in the presence of someone else who then doesn't intervene, you're talking about a really small population that I would hope doesn't meaningfully add to the overall population of in prison. And then in terms of the disparate impact on minority communities, it is possible. Certainly, but on the other hand, given the disproportionate misuses of force against Black Americans and other minority groups, Native Americans as well, I would also argue that this sort of law could also help, particularly racial and other ethnic minorities. So it's, I think, not clear that that there would necessarily be harms, and I see quite a lot of upside. And I also don't see this as a criminal law that is applied to everyone, and therefore could be exploited in ways that meaningfully add to mass incarceration and discrimination. Questions? Thank you, everybody.